topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Experts show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Good afternoon, South Florida. Welcome to another Ask the Expert show where we bring you the finest experts in the field of legal, health, financial, and home improvement. We have a whole new audience today from TikTok. We've finally been accepted to come on TikTok and do our shows live here. We are so excited about this. This is probably my easiest show to do because you, the viewers and the listeners, send in questions throughout the month. And in fact, you send so many questions in, we can't get to them all. But let me introduce you to the star of the show, attorney Robert K. Bender Rimbaum.
Hello and good afternoon, everybody.
This is so easy to him. He's done so many shows. And hey, by the way, you look great.
Oh, thank you. You look great yourself.
Okay, stop with that. Okay. So since we've got all these new listeners, and I don't know if you've noticed, our YouTube numbers are like sky high. Tell people about K. Bender Rimbaum.
Well, K. Bender Rimbaum is a law firm that focuses its attention on community association representation, condominium association, homeowner association, cooperatives are the primary client base of the firm. We provide all aspects of the daily legal needs of these associations, be it collections of unpaid assessments, interpretations of the governing documents, advising the board what they can and cannot do in situations, negotiating contracts, dealing with construction defects, complex litigation matters, bankruptcy issues, bank foreclosure defense, anything you can think of that an association has to deal with, we've been doing for 35 years in this location, and I've been doing many years before that. We do that out of our 4 offices. Main office is in Pompano Beach. We have an office in Palm Beach Gardens. We have an office in Orlando and an office in Tampa.
Just to remind you, we do our Orlando show is the last Thursday of each month at 5 o'clock Eastern time. And we do our Tampa show the last Tuesday of the month, 5 o'clock Eastern time. I got to brag on this firm because we talk to community association firms all across the country. And I got to tell you, this firm is such a believer in education. They offer so many free education courses each month. They do shows like this. And Robert, I got to tell you, there's not a lot of firms that do so much educating as your firm does.
That is true.
So the way we do our show is we take your questions. We're not going to be able to take questions yet from TikTok because we've got so many questions here. Plus, we've got our chat line. But I promise you, starting next month, we will take your community association questions. Are you ready to go?
Ready to go.
Okay, we're going to start off with Eric in Miami. For an HOA, the board passed a special assessment for major clubhouse repairs. An owner believes that the governing documents require an owner vote. The board disagrees. What are the owner's options?
Well, the owners don't have a lot of options here. Under Florida law, when an association is faced with a situation of having to make repairs, which are the obligation of the association under its maintenance function in the governing documents, the association has the power to assess for its needs, regardless of whether or not there are provisions in the documents that require a vote of the owners. For homeowners associations, there isn't a statutory restriction on material alterations as there is in condominiums, and that's a specialized term in the condominium field. Both situations, HOAs and condominiums, do contain this exception when you're dealing with necessary maintenance items that fall within the obligations of the association under the governing documents. The board must undertake them, and they must assess for them regardless of whether or not a vote of the owners is called for in the governing documents. So based on the question, these are identified as necessary repairs, which is maintenance, and that would fall within the exception of any unit owner vote requirement in the documents.
Rick in Pompano Beach wants to know, for board meetings, can you have a Zoom-only meeting, or do you have to also provide an in-person meeting as well?
Did he say HOA or condo?
He did not.
Well, that's a problem because they're different.
They
In
are.
a condominium, the statute now provides that there must be an on-site location when the board is having its meeting on Zoom. But there is no such provision in the HOA statute. So while we suggest to our HOA clients that it's good business practice to have a place for owners who might not have access to Zoom or might not be comfortable with Zoom to come and observe the board meeting, the statute doesn't mandate it for HOAs, only condominiums.
JD in Orlando says, we have a board member who has been on the board for 13 years. He will be placed on the board again on June 15th at our election. Can he serve past 8 limits by the new statute? Can he serve out term? We have other owners who want to serve on the board when his 8 consecutive years expires. Will he be able to serve out the full term, or is he off as of July 1st?
And what this is referring to was a change in the statute that was adopted in 2018 for condominiums only. The change in 2018 said that a board member may not serve more than 8 consecutive terms, with the exception of a situation when there isn't enough other candidates running to serve, or if the candidate gets more than a supermajority vote of the owners in favor of them serving another year. The 8 years began on July 1, 2018. So that means the 8 years would expire on June 30th of 2026. Since this situation has the election on June 15th, that's before the July 1st cutoff. The individual can continue to serve even though it's beyond the 8 years, and that limitation on consecutive service would not kick in until the following annual meeting in 2027. It doesn't require the individual to get off the board on July 1 of this year. So that one slips under the little loophole.
Again, I want to remind, we love getting your questions. It makes the show. Please let us know if you are a HOA or condo. It does make a difference, believe it or not. Just let us know. You can just put an H or a C if you want. Okay, let's go to Randy in Palm Beach. Why can't any unauthorized external attachment to association property be removed immediately by the association?
Okay, again, we don't know if this is a condo or an HOA, but the answer for this one is generally going to be similar. A lot will depend on what the governing documents provide for such things. And the other aspect is whether the association wants to be the party paying for it. If an owner makes an alteration to the common areas and it's not allowed and the board wants to compel them to remove it or pay the cost of removing it, it may require legal action. If the board just removes it, then the board's going to be paying for it with association common funds, which many times the association doesn't want to do. So the situation may depend on whether or not they would immediately do it or not. And it would depend on the nature of the alteration. If the alteration is something that might have a value even when removed, the association might be exposing itself to certain liability by removing it itself rather than compelling the owner to do so. So the facts and circumstances of the alteration need to be considered before that decision is made.
Well, we've got a lot of questions coming in on the chat line. I guess you can see them. Let me go to Eugene. Does the HOA violation fine hearing notice to the homeowner need to be mailed 14 days prior to the fining committee hearing or received 14 days prior to the hearing?
The 14 days refers to the mailing date, not the receiving date.
Prior to the hearing.
Yes, must be mailed at least 14 days prior to the date of the hearing.
Okay. Kirsten wants to know, thank you for providing this incredibly valuable and informative webinar. What kind of recourse does the members of a condominium have when the board of directors does a material alteration without a vote?
Well, for condominiums, you have the option of making a complaint to the Division of Condominiums within the Department of Business and Professional Regulation, which is an administrative enforcement arm for certain violations that are made by condominium associations, which the complaining owner will not have to hire a lawyer and pay the costs associated with it. Although if the association gets fined for the violation, which is a possibility, the complaining owner is going to pay a portion of that fine based upon their percentage interest in the condominium. The other alternative is to engage an attorney to represent the unit owners and pursue the board for the violation of the statute and documents and the material alteration without a vote. But it's important to be certain whether or not the material alteration is actually the material alteration as contemplated by the statute, or whether it might fall within the exception we talked about with the earlier question as to whether it's necessary maintenance, in which case a vote of the owners would not be required.
Let's go to Mize. We had a surplus in our condo operating account. Do we have to take this to the owners to keep the surplus in the operating account by Florida 718?
I'm guessing that's a condominium then. When there's a surplus of operating funds at the end of a fiscal year for the condominium association, the statute provides that it's determined by the board what to do with it. The options that the board has is to apply it against future assessments or to return it to the unit owners. It's pretty rare to have an association returning money. They would tend to incorporate that into the next year's budget, which could reduce the needs for assessments in the upcoming year. And that's typically what's done.
You know, I wish you could see what I see over here, Robert. All the people on TikTok joining our show. That is wonderful. Again, we will start taking your questions next month. We have got so many questions in our chat line. Here is an HOA. If 10% of the membership petition the board to hold a special meeting with the purpose stated and the board ignores the request, what is the next step? The attorneys, we're getting so many questions in, this board is moving.
You get it all? Yeah, I see the question.
Okay. So the attorneys never responded. I know that's not your office.
I'm assuming the question is for the board to hold a board meeting as opposed to a membership meeting on the 10%, and to address a specific item. There is no time frame in the statute for the board to take action. They should take action, but unfortunately for unit owners in a HOA, there is no administrative agency to bring the complaint to when the board ignores such a request. So that only leaves the option of bringing legal action to compel the board to do what the statute requires the board to do, which means hire an attorney, make a demand, follow the pre-suit litigation requirements of mandatory mediation, and then if that doesn't work, file a lawsuit, which can be expensive to the homeowner that is footing the bill for their own side. Now, if you end up filing a lawsuit and prevail, it's possible to recover your attorney fees in that event. But if there's a settlement in any point prior to that achieves the goal, there may not be a recovery of attorney's fees. So that is something to keep in mind. The options for homeowners in that setting is very limited, unfortunately.
Here's a question we get a lot of. In fact, I don't always put them on every month because we get so many of these questions. How can the board of directors or management company legally verify an animal is a service animal? We are a condo. We think the owner might have forged the papers. We get a lot of those.
Well, under the Fair Housing Act, both in state and federal level, the requesting resident has to produce something from a qualified medical professional that identifies the specific need for the animal that's being requested as an accommodation to a no pet restriction within the governing documents. There's a fairly limited opportunity for the board to look deeper into the request. And because of the potential exposure that the association might have to a claim of discrimination if there's a misstep in this process, we generally recommend that the board not do anything without consulting with the association attorney to make sure that they're not going to cross any lines. The requirement that the owners have from the medical provider is to show that there's a specific major life function that's being jeopardized by the inability to have this animal reside with them, that this specific animal relieves so they can have full use and enjoyment of their property. And that's a fairly low bar for a medical professional to have to cross, but it has to be a bona fide medical professional. It has to be one that has actually seen the individual who claims to be the patient of this medical professional. And there are laws that make the professionals providing false information subject to criminal prosecution if they violate it within the state of Florida. So you really need to involve the association attorney at a very early stage. We also provide for our clients and recommend, if they don't have us as their attorney, that they have a package prepared for them that they can give to a requesting owner that provides for all the information that the association is entitled to and will need in order to make the most informed decision on the request.
Okay. This is an HOA question. The board ran 2 annual meetings and was called out as defective. They are not redoing the meeting. Does this qualify for a receiver?
The board tried to hold a meeting, but their process was defective. Is that what it says?
Yes. They're not going to redo the meeting.
But they do have a board. That's what it sounds like. Well, if
yes.
The only thing that qualifies for a receiver or a request for a receiver is that there not be a board in place that's functioning. And the point of a receiver is to act in the place of the board and primarily to run an election to get a proper board seated and to operate the association during the period that it's doing that. And it takes a petition to the circuit court. It takes notification of all the owners for at least 30 days prior to taking such action. And if you're successful in having a receiver appointed, then the association has to pay for all of the charges for the time the receiver puts in, plus whatever the receiver does in the capacity as the board. So it's a very big risk to an association to have that. Under the circumstances here where the board messed up on its own in scheduling or holding an annual election, it's probably a faster approach to do it through litigation than to try and go through a receiver. It would be more likely successful in achieving the goal for less expense than having a receiver. And in all likelihood, since the board is in existence, a receiver likely would not be appointed by a court anyway. But that's an interesting question and a little bit complicated.
I'm going to take this last question before we go to break. This is from a board member. Can we change condo owners who file bogus lawsuits that cost thousands in deductible insurance and lawyer fees?
You mean charge them?
Yes. It says, can we charge condo owners who file bogus lawsuits?
Well, who decides what's bogus or not?
Yeah, that's true.
If there's a lawsuit that's filed and the association prevails, the association should be able to get an order of its attorney's fees and costs from the court in that situation. If a lawsuit is filed and time is spent and ultimately dropped, it's possible that the association would be considered the prevailing party and entitled to the order of the court. Charging the owners for those types of activity is not something the law currently allows. In certain situations, we have clients amend their documents to put in a provision that if the association pursues an owner for a violation and the owner complies without the need for litigation, or even if there is litigation, the attorney's fees and costs that the association incurs can then be assessed against the individual unit. If you don't have a provision in your documents to allow for individual assessments to owners, then you won't be able to charge individual charges to owners. That has to be absorbed by the community as a whole.
We're going to go to a break now. Give people the phone number, how they can contact your office.
You can reach K. Bender Rambam at 800-974-0680. You can write to us at info@kbrlegal.com or go to our website, kbrlegal.com. On the first page, there's a contact box that you fill out, and we will get back to you within a day or so.
We're going to go to break. We'll be right back with more. K. Bender Rambam. We'll be right back.
K. Bender Rembam is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rembaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
We are back. We want to welcome our new TikTok audience. Amazing. I am just, because we just started this last week of how many people were invited to come on the show. What we do now after our break is we talk about for the next 3 or 4 minutes, K. Bender Rembaum has these free, incredible classes that they offer. And I'm going to let Robert tell you about all the classes that are coming up.
Well, thank you, Steve. On May the 15th at 11 o'clock on Zoom, we have a class called HOA Record Keeping and Records Access. This has a new, what they call EH1 CEU, 1 credit for managers who manage an HOA. And it might have 1 HOA, or whether it's 1 or more, and also 1 CEU for board members of the HOA. It's hosted by GRS Management, and Danielle Brennan of our Palm Beach Gardens office will be leading that class. May the 18th at 11 o'clock on Zoom is a condo board member 1-hour continuing education update. It's a legal update for condos, which is a new requirement. In addition to the 4 hours, they're supposed to get another 1 hour of continuing education. So that's this one. Alan Schwartzide from our Orlando office will be leading that hour-long presentations hosted by ACAM Management. May the 19th at 12 noon on Zoom, the Castle Group's Association Matters. It's frequently asked questions by board members in Florida CAMs. There's no continuing education credit, but it's a very interesting hour and a half or so. We'll have Jeffrey Rembaum and Alan Schwartzide both participating in that particular presentation. On May the 20th at 8:30 a.m., a live event, Breakfast and Learn at the Art Serve in Fort Lauderdale, the importance of updating governing documents of the association. Lisa McGill from Pompano Beach office will be presenting. There's 1 continuing education for CAMs and 1 continuation for HOA board members, hosted by Association Community Education, which is known as ACE. Then on May the 27th, 11 a.m. on Zoom, HOA board member certification led by Alan Schwartzide, hosted by Empire Management. May 27th at 3 p.m. on Zoom, HOA meeting requirements and elections. Again, Alan Schwartzide from Orlando will be presenting. There's 2 CEUs for CAMs and also board members of an HOA. That's hosted by Trident Management. And on May the 28th at 11 a.m. on Zoom, HOA Financial Literacy and Transparency. Kirsten Hens from our Tampa office will be presenting. There's 2 CEUs for CAMs and board members for HOA. And the last item on the 29th of May at 11 a.m. on Zoom, guest restrictions and screening of tenants and new owners, presented by Emily Gannon of our Pompano Beach office with 1 CEU for CAMs and board members of an HOA, also hosted by ACAM Management. That's what's left in May.
You know, I'm sitting here listening to all the different courses you offer. And with all these new people I'm looking at coming on the show, And no one could do this any better. You're the senior partner of K. Bender Rimbaum. Tell me how your firm is different from other firms.
Well, the firm, which began in 1992 and has been providing services continuously ever since, focuses on the service aspect of the industry that we are in. We know that our clients are primarily lay people. They're not legal professionals. They're not management professionals. They need to be treated with the respect that they deserve and not be presented with information that's so complex that they need to hire an attorney to translate for them. We provide our information quickly, efficiently, time effectively, cost effectively, in a manner that's understandable to the layperson. As you mentioned, from time to time, we have live receptionists that answer the phone, and we have prompt service response. Our response time to our clients is primarily within the same day or within 24 hours of any time they reach out. You may not get a full answer in that amount of time, but you know that we've got your inquiry and we're working on it, and an indication of how long we anticipate it'll take. So we also have a large portion of our association attorneys are board certified by the Florida Bar. Of the roughly 200 board certified attorneys within the state, I believe our number is around 11. Plus, we have one board certified attorney in construction defect litigation, which means that we have a higher level of educational background, experience background, and have been identified by the Florida Bar as an expert in our field. So as I say, there's roughly 200, a little more than that, in the whole state of Florida. And we have a large portion of that at K. Bender Rimbaum. So those are some of the, we also have one of the most effective collection departments that we've run across in the state. We know that pursuit of unpaid assessments is not something that associations enjoy having to undertake, but without the lifeblood of the community, the assessment payments by the owners in a timely fashion, the boards are unable to properly perform their functions and operate their community. And we pride ourselves on the program that we put into place many years ago, and we provide these services on a deferred fee basis and advancing of costs in many instances. And all the information that is desired or needed about any existing matter is available 24/7 on our website to our clients on all the matters that they're handling. Also on the website, in the calendar section, is all these classes that we've gone over for this month, plus what's coming up in upcoming months. And anybody interested can simply go to the website, click on the calendar, and pick the one that they are interested in, and get a reservation for the Zoom information that they would need to attend.
I got to tell you, you've got one of the greatest websites. There is so much great information on there. Like I said, I do this all over the United States. I've never seen a website offer so much great information as you do. Let's get back to the questions. Can the board of directors block the sale of a condo when proper permits were not filed, or the recent remodel and flip?
Well, it's generally not the purview of the association to oversee whether permits are obtained when owners do things within their units, but the association does have the ability to notify the local building department's enforcement section of a situation they become aware of. There is the need to exercise some caution on notification of city officials of such circumstances, and that we've seen in the past the occasional time when the enforcement department will cite the association as opposed to the individual unit owner that has undertaken the work without the permit. So you don't want to find yourself in that position of having to address a citation that really wasn't the fault of the association. So you have to be careful when doing that. It would need to be something specific in the governing documents of the association that allows for that condition to be a basis of a decision to approve or disapprove a potential sale or lease of the unit.
TBC board wants to know, can the board inspect a condominium that is vacant between tenants or before a sale?
The board generally has the entitlement to inspect a unit when there's reason to believe there's a condition there that might affect the safety of the common elements or other units. That doesn't mean just because the unit's vacant, you can go in and inspect it. You have to have a bona fide basis for doing so.
Okay. Do you perform, this is a new question, do you perform many litigation cases that continue into a full lawsuit?
Yes. we have a large number of attorneys who are doing just litigation, and they're all in lawsuits. We have literally hundreds of active lawsuits that are currently going on at the moment that are not collections, they're actual covenant violations or other types of similar situations.
Here's sort of a long question. Walt in Miami wants to know, since 55 plus law is exception to fair housing, is a condo association allowed to include ownership, parentheses, deed title holders, as well as occupancy as the basis of their 55 plus requirement at all versus solely occupancy, which is the narrow perimeter of the statute? In other words, is it totally of the exception for 55 based on occupancy, and any ownership restricting related to 55 plus requirements in the bylaws is null and void? Wow.
Well, the bottom line of that question is the correct answer. And the Federal Fair Housing Act that began in 1988 created the exception to allow a community to, in essence, discriminate against families with children if they met certain criteria that has evolved over time, which is basically now that 80% of the units are occupied by at least one person over the age of 55 years, and that they maintain a census in their records that confirms that. There is a little bit of a issue between state and federal law on this, in that under state law, you're required to be 100% as opposed to the 80% on any restriction within your governing documents. The 80% was included in the fair housing laws to address situations when there's an inheritance of a property by somebody under the age of 55 that creates a hardship for them, but would be required to be allowed so long as they stay above the 80% requirement. But it all focuses on occupancy and not ownership. It doesn't matter the age of the owner, only the occupants. And in fact, having the age restriction would run afoul of the other part of the fair housing law that says you can't discriminate based on age. There is the allowance on the occupancy side if it's within the exception for housing for older persons, but you cannot restrict ownership based on the age of the individual, other than they have to be over 18 years, because that's the legal age to own property.
Okay. Here's a question. I bet you get a lot of. They want to know: do you only support the board or homeowners in lawsuits?
We represent associations, and associations are operated by the board, but we don't represent the board per se. We represent the association, the corporation that is the association. Boards change, but our representation remains the same as to the association itself. As a general aspect of our practice, we do not take on representation of individual homeowners, with the exception of if they're taking over control of their association through recall or in the election process. We may provide some assistance in that regard, but our general practice is representing associations.
Ben in Delray Beach wants to know: I have a person that wants to buy in a 55 plus, but only live there part-time, where their 20-year-old son will be full-time. Is that allowed?
Well, that would be in violation of the restriction, because it does require a permanent resident of over the age of 55. And in Florida, permanent is generally considered 6 months and a day. So if the individual has it listed as his homestead, and if the individual has their driver's license at that location, these are items of evidence that's a permanent residence, and maybe travels for work and may seem like a part-time resident, but it really requires the permanent occupant to be over the age of 55.
Barry in Boca Raton wants to know: what criteria do you recommend for an HOA to foreclose on a house?
Well, what we look to for HOAs and condos as well is what the governing documents provides for when an assessment is considered delinquent. It is our general philosophy that you want to commence collections as soon as possible if you want to maximize your ability to actually collect on what is due to the association. Now, there are provisions in the statute that require certain amounts of notices that go out, which take a significant amount of time before an association can get to foreclosure. And the more time that goes by before you can complete that foreclosure process, the less and less likely the association is of actually collecting the money. May end up owning a unit that's subject to mortgages and may not have equity, may have equity, but it's a limited remedy that's available to associations, albeit very powerful. So we look to the documents to see when somebody's delinquent. Typically, it's within the first month or by 30 days after the due date. And at that point, when the association should be sending its first notice of intent to lien, which is a requirement before it can refer anything to the attorneys and be entitled to recover attorney's fees. So that's a 30-day requirement on the association initially. Once it's turned over to the law firm, the first notice has to be 45 days with no lien, just notice of intent to file a lien. Then the second notice after those 45 days with a lien is another 45 days. So you're already at 90 plus 30, 120 days from the time of a delinquency before you can even consider starting a foreclosure case. Now, quite often when the attorney gets involved, the owners respond, they try to work things out, or they try and delay, one or the other, or they ignore and you never hear from them. So our general guidance is to commence the process as soon as the documents allow for them, because that will get you your greatest chance of recovering your funds.
Okay. Ronald in Boca Raton says, I really like the questions that people send in, but they don't compliment you enough to tell you how great your show is. I just want
Nobody
to tell
does.
you, I have watched your show for several. What's that?
Nobody compliments us enough.
Said, I know. Yes. He said, I watched your show for several years. It's the most informative show out there. I want to know, can I legally record a financial, community association meeting when providing advance notice to the board management? I was given a legal letter telling me this was illegal as it is not a board meeting.
Well, the recording entitlement falls to, did he say HOA or condo in this one? I don't recall. Steve?
Yes.
Are you there? Is it HOA or condo?
It's a condo.
It's a condo, okay. So certain committee meetings are required to be treated the same as a board meeting. And the financial, the budgetary meetings fall within that category. And that should be something that an owner can attend and record, just like any other. So if there's a question and it's a condo, that owner can send a complaint into the Division of Condominiums Enforcement Section, and they will make inquiry to the association as to whether or not that was an actual committee meeting that was required to be open and allowing recording, and then go from there.
Okay, Craig in Delray Beach. This is a condo. It says, in a condo with declarations that prohibit corporate ownership, how is it best to address a finding that several units are under corporate ownership, such as an LLC?
Well, first problem you have is an LLC is not a corporation. And a lot of people don't quite recognize that. And older documents do refer to corporate ownership. And while the intent was a little broader than just corporations, unfortunately, when you're putting them in documents of this nature, you have to treat them with the specificity that they're written in. So corporate limitations are just that for corporations. So that doesn't apply to an LLC. It doesn't apply to a partnership. It doesn't apply to a trust. So if you want to prohibit those types of ownerships, you have to be more specific in the provisions of your governing documents. And that may require an amendment in order to do that. We've had many of our clients discover an entity had acquired an interest in their community that violated, and we can take formal legal action to compel them to divest that interest to an individual. But it has to be the right type of entity that is expressly indicated in the governing documents.
I can't believe the show is over. I can't believe it. Well,
Let's go fast.
First of all, I want to thank everybody in the chat line for all the questions. And boy, you are a star, bro. I got to tell you, people love you. And
I love
TikTok, I bet you we had over 800 people. I know you do. Tell people how they can reach K. Bender Rembaum.
K. Bender Rembaum can be reached at 800-974-0680 for any of the 4 offices. You can write to us at info@kbrlegal.com, or you can go to our website, kbrlegal.com, and fill out the contact information on the first page of the website, and we will reach back to you very quickly.
I want to get to just real quickly. We just got a text in. A board member wants to know if they're already under contract to a community association law firm, can they still speak to you for a second opinion?
Generally, retaining a law firm is not exclusive. You can have as many lawyers as you want, and you can have as many different opinions as you would like to get. So the short answer is yes. If you have another attorney, you can certainly reach out to us, and we can't reach out to you and solicit you, but you can reach out to us and ask us to provide representation. Or if there's an opinion you've received that you're not sure is correct, and we certainly can provide a second opinion to assist you in that regard. Sometimes a community wants to compare, and we'll give some matters to one law firm and other matters to another law firm and see how they do. And we're always happy to be a part of such a situation because we like to show what we can do. And typically we find that we end up with a client.
Well, I'm glad you're feeling better. You look better, and you'll be back again with us next month, the first Thursday of the month at 5 o'clock Eastern time. I want to thank all of our new TikTok listeners and viewers. Hey, we'll see you next month.
Yes, sir. Have a good one.
You too. That's attorney Robert K. Bender Rimbaum, incredible law firm. If you have a condo or an HOA association, I'm telling you, do yourself a favor, do your board a favor, give them a call. That's it for us today. We'll be back in with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.